Any mention?
With the permission of my court, my lord, may I make a mention for listing of a matter today, my lord? We had the matter came up in the cause list. It got deleted yesterday, my lord, in the evening, and we were asked to make a mention before my lords only. And this is very strange, my lord. It should have come up for hearing. We filed it some time back and got deleted only. So, and then there is a urgent prayer because all our accounts came to be freeze, including the lawyers, including myself, by the deputy collector without any powers, my lord.
Matter was posted for hearing?
Yes, my lord, it was posted for hearing today and got deleted from the cause list yesterday, and we were asked by the court master, by the registrar, to make a mention before this honorable court late in the evening. If it can be accommodated, my lord, today only, I'll be very grateful. Not much matters are there. Cause list is not very heavy today.
Okay.
I'm so grateful. Much obliged.
May it please your lordship. My lordship, I'm mentioning item number 12 of the supplementary list, my lord. It's on the hearing list. My lord, this matter has been taken to before the Apex Court, my lord, and we have filed it before the Apex Court.
What is this matter about?
This matter is about the service benefits of district court judicial staff. Yes, my lord.
So you have taken up the matter before the Apex Court?
Yes, my lord, because there are also other pending matters there.
So matter has become infructuous then?
Yes, my lord.
So you are withdrawing the matter?
No, I think what my friend is suggesting is that they have filed a transfer petition in the Honorable Supreme Court. So transfer petition is yet to be taken up,
yes,
and any sort of order being passed. So till that time, matter remains before my lord, till Supreme Court, in its wisdom, either transfers or not transfers.
There were three matters.
Yeah, because earlier I think there was an observation by this court,
my lord,
though not being certain of facts,
my lord,
that there are similar matters pending for the Apex Court.
Yes, ma'am.
You said they are distinguishable.
My lord, in fact, what had happened is for the last 2 years, the state has tried to impress that the same issue is pending before the Honorable Supreme Court. Now, having failed to point out what is the exact issue pending before the Supreme Court, they've filed a transfer petition to transfer this matter itself.
Right. Now, my lord, there were three petitions which were filed before this honorable court, my lord. Two regarding the salaries and wages payable to the employees, my lord. Two matters have been transferred by the Honorable Supreme Court day before yesterday. This matter will be taken up for hearing in the coming month of January, by first week of January, my lord. So, the lordship, I was praying that it should be listed on reopening.
Okay, we'll see.
My lord, if state can supply the details of the filing.
Yes, details are there.
Not necessary to be noted. Just adjourn the matter.
Yes, ma'am.
We will see as and when, if you take steps, or rather if any orders passed by Supreme Court, then you can
Very
produce the order on the next day.
very
From pre-made by Leonard AG. This is matter to vacation.
pendency in the Supreme Court can be reflected, my lord.
We'll see, because
We'll see.
as of now nothing is there.
We don't know. Unless-
May it please your lordship. Your lordship, I beg to make a mention of one unlisted item, my lordship. If it can be listed to the bail matter. Yes.
Okay.
Obliged.
See if time permits.
Yes, your lordship. Obliged.
Your lordship, item number 2 of the daily list, your lordship, which is fixed for hearing. It is a joint request by both the parties, your lordship, for listing it after the vacation, because we'll not be able to finish it today, your lordship, in any case.
After vacation. 2 more.
Number 2. Highly obliged, my lord.
Please, lordship, I'd like to make mention of item number 3 from daily list, lordship.
Three and 4 are connected, isn't it?
Yes, lordship.
Connected matter. Can be taken out also to vacation, Mother.
Vacation,
You are in both cases.
no, your lordship, only for
I
item
am in
number
both
3.
cases, Mother.
You are in both.
In one case, I am the prisoner. In one case, I am the respondent.
Is that complaint matter?
Madam?
complaint before the EC?
No, Madam, this is
Or inquiry?
pertaining to the election, Madam. It's election petition, Madam. Election,
I think we are on the, if I recall,
Madam.
we are on the issue of whether there's a tribunal in place, whether matter is to be
Whether it should go to
taken
the
up by
EC or whether this honorable court will deal with the matter.
Yes.
I raised that issue against the order of the tribunal. Appellate authority is the EC.
My lord will have to examine that. That is the entire issue, Madam. Because this is with one matter is with where delay was condoned. In one matter, the delay was not condoned, my lord.
Okay then. On pre-made by the parties, let's just matter the petition. So that's 3 and 4.
My lord, the interim order is there, my lord, in my case, WPC 209, item 4. That may continue, my lord.
Because item 4, so interim order will continue until the next returnable date.
Obliged.
Supplementary list, item number 1.
My lord, in terms of the last order, status report and case diary I have received, my lord. My lord will kindly. Here is the status report, my lord.
Yes.
If my lord pleases to come to page number 6, my lord, of the status report, last 2 paragraphs. After
Page
6,
last.
my lord, page 6.
Yes.
After observing all the
Where is
necessary formalities, absconding
Just
charge sheet
a
has
minute.
been submitted.
You're referring to paragraph?
Paragraph second paragraph onwards, that on completion
That
of the
completion.
investigation of the case,
Okay.
accused persons has been charge sheeted, namely so and so, so and so, so and so, 4 Imanul, 5 Nizamuddin, and the following 3 persons have been found absconding for avoiding of police arrest. Source has been engaged to collect so and so. The accused person CDR of the persons was received. Tura, it is found that the mobile number are found to be switched off. The requisition was again to trace the IMI of the mobile, and based on the technical inputs, continuous efforts have been made to conduct search. After observing all the necessary formalities, absconding charge sheet has been submitted against the 3 accused persons, namely Gulzar Sheikh, then Gulbahar Sheikh, and Taimur Ali. So charge sheet has been filed, my lord, as the absconding charge sheet has been filed, and hence prayed to be discharged, and some others also were in the course of filing of the charge sheet, they were to be, the IO has prayed for discharge of these 5 persons. My lord, in this case, I think they will have to take regular bail since the charge sheet has already been filed, my lord. Now,
Yes. And how many petitioners are here?
Yeah, three lordship. Altogether, 13 names were named in the FIR lordship. Now, as I stated in the earlier bail petition lordship, that is, there are 6 person lordship. They were not present. They were not present on the spot because they are son and brother of Fulbahar Sheikh. And in fact, the Fulbahar Sheikh is the victim. As I submitted earlier, he was a hetman. He is the hetman of the place. Now, as per the records, I am not saying lordship, this is the records, that the victim was dealing with some antisocial activities like drugs and all. As a hetman of the village, he has reprimanded the victim. Now that did not go well, lordship. So he...
But you see, that's beside the point. Those are a matter of...
yes, yes. So my lord...
But the fact remains, Mr. Sheikh, see, you have been listed as absconding.
Yes, lordship.
So, it means that you have not cooperated with the investigation.
My lord, true lordship.
You should have at least at the initial stage either file an application for anticipatory bail or at least cooperate. But
my lord will kindly appreciate.
When did the incident occurred?
June, lordship.
June this year.
June this year.
21.
My lord will kindly appreciate 2 bail I have moved before. Altogether, lordship.
If you have moved bail, then why is it noted that you are?
Yes, 2 bail.
This is a charge sheet.
Not these people there. No.
Yes, lordship. My lord will kindly see, lordship, that bail.
Where?
Lordship, that is the last bail, 40 space 46.
This is anticipatory bail.
Yes, lordship.
This was rejected.
Rejected on the ground, not rejected in fact, lordship, because lordship, here before this lordship, there are 3 petitioners before this lordship, and 3 petitioners has already granted bail by this honorable court. Now this 6-person lordship, this as well as the petitioner which my lord have granted bail, lordship, these 6 petitioners has filed a anticipatory bail before the court below, lordship. Now all bail petitions were rejected by the learned court except Fulbahar, lordship. Now out of 6 lordship, 3 petitioners approached this honorable court. They were also brother and son of the Fulbahar Sheikh, lordship. That has already granted bail by this honorable court. Now the order which my lord have passed, lordship, they had relied that order and they moved bail before there. And these petitioners' bail were not considered on the ground that since earlier bail petition has been rejected by this honorable court, so that this is not a change in circumstances, the proper procedure would be for approaching this honorable court. Because so far as the other 3 petitioners are concerned, they have obtained bail from this honorable court. So the court has said that I cannot grant the bail, you go to the higher court. Lord, that my lord will see the page 46 below down, lordship. So where is the question of absconding, my lord? Axe is hanging on my head, lordship. Obviously, lordship. And now, because I was framed, why? Because I am the brother and son of Fulbahar Sheikh. Now 5 person has been, name has been deleted from the area of the... Now I'll face the trial. That will prove during the course of the trial, lordship. Now my lord will see the earlier bail order, lordship. My lord has page 42, lordship.
Yes.
I'll rely page 42, para 5, lordship. This is same set of circumstances, lordship. Per contra, Mr. So-and-so learned additionals appearing on behalf of the state has submitted that the fact it was a case of mob violence and the lynching of the deceased so-and-so cannot be denied. And also the fact that several of the attackers who have been assaulted, the said this is also relatives of so-and-so is also a fact. It is also submitted that the case being serious in nature, it would be but proper for the investigation to be allowed to be carried out by the investigation without any hindrance of the said process. Now, why my lord has granted bail in this case? Because one of the accused who hit the victim in the CD, he has narrated the incident, who are the person involved. He has to, beside him, 3 persons' name. And those 3, as well as the Mukul Hussain, they have surrendered. 4 persons, they have surrendered, they obtained bail. And because of that only, my lord has granted bail to the petitioner in the earlier case, lordship. Same, in that, they were also the relatives of the Fulbar Sheikh. These also one son and the other is 2 brothers. They were not present. Now, the CD also reflect it was a case of mob violence. 500 people were gathered and the incident happened in front of the police personnel. Now, because my name is only appeared in the FIR, that does not mean that I was involved. I was not present in the spot. Whatever may be in the meantime charge sheet has been filed, that does not mean that my remedy to avail the anticipatory bail is gone, lordship.
Yes, of course.
My lord will see the pace who have approached the honorable court earlier, lordship, pace that earlier bail, that bail petition was rejected by the court below, lordship, page 35.
Yes.
Gule Hussain, Abu Tahir and Syed Ali granted bail by this honorable court. Now Golbahar Sheikh, Golzar Sheikh and Taimur.
When this matter, was there any interim order passed in this case?
My lord is there.
Before, between the last order and today, have you appeared before the IO?
My lord will kindly see the interim order. My lord, I have 11 was the date for granting interim order, 12 was the holiday. And in the earlier occasion also, lordship, when my lord has granted bail for those without certified copy, so I have applied the certified copy day before yesterday. I got yesterday and they appeared yesterday, but he was not available. That they made the OC. They made the OC saying that the IO concern has moved to Shillong, lordship. This is the certified copy, lordship. My lord will see very short time. 11 granted bail, 12 was the holiday, and 15 I applied. I tried to get it by 15 itself, but I got it yesterday, and yesterday I sent through WhatsApp, lordship. Now why I have? Because earlier occasion also they refused to accept the online copy, lordship.
My lord,
Because this is a case of
submit,
anticipatory bail.
My lord, what I am saying is that not to deny them the right of bail, my lord. Only thing is that let the bail be made absolute to them. Then it can be disposed of. Then they will face the trial, my lord.
I'll face the trial, lordship.
That's it, my lord. What other option we are having? At the most, my lord, because the charge sheet has already been filed, my lord. Either they will go back. Either they will go back to the trial court for getting a regular bail, or this interim bail which was given earlier, my lord. My lord will have the discussion either to reject it or to make it absolute. So my lord can very well. I leave it to the discussion of this honorable court to pass appropriate order.
And the direction is as and when required, lordship. It is not that I have already, they have informed the IO that they got the interim bail. The direction is given as and when called. But despite that, yesterday I attempted to appear, lordship. It is not that. And I made the OC. Now charge sheet has already been filed. Who is the question of tampering? There is a newspaper reporting that it was a case of mob violence.
Have you filed the case diary?
Yes, my lord. The case diary is also there. Copy of the case diary, my lord.
Have you flagged
My lord,
any evidence or observation against the?
My lord, what the IO has informed is that there are videographic video of the incident, my lord, and those videos will be placed before the trial court, my lord. This may not.
It has to be noted there.
This is
what is,
my lord.
See, as regard the involvement of the.
No, lordship.
What is his observation or finding?
There is no evidence.
It is given in a form of videography on DVDs, my lord.
That is true, but he has to indicate. You see.
My lord, those accused persons are identifiable in the videos, my lord. That is what it indicates, my lord. Those.
Did he say that?
Yes, my lord.
Whether that video should reflect that they were present at the very
That's a different
time of the assault, or they have gone after the incident.
What the court is concerned here is
Lordship.
only your prima facie involvement.
Yes, Lordship.
Whether you are there or not.
Yeah. That,
Whether you have taken part in the attack, that's
Yes.
a different thing. That would be taken care of by
Yes,
the
Lordship.
trial court.
My lord, there.
no, I have.
Just a minute.
In para 8 of the earlier judgment, the main accused has narrated the incident. That has reflected in the order sheet, Lordship. Page 43. And that was the part of the CD. My learned senior was reading out the CD. Page 43.
That you have submitted.
Yes, Lordship. Now I'll face the trial, Lordship, because since case has been charge-sheeted, at least some protection may be given. If I am involved, then obviously I'll be tried and law will take its own course.
It talks about the videography of the incident, my lord, which has been seized by the IO. DVD. And the IO also is very clear that the visual presence is there in the videos, my lord.
But Mr. S.A. Sheikh, counsel for the petitioners. Also heard Mr. S. Sengupta, learned additional PP, who has also produced the case diary as well as the status report filed by the IO. It is the submission of the learned additional PP that the charge sheet in this case has been filed, and the petitioners herein have also been named as accused persons, meaning that is established a prima facie case against them as far as their involvement in the incident which took place on when did the incident took place?
21st June 2025.
21st June 2025. Atau boleh biar umum tu? Wherein?
My lord, in the status report, page 5, my lord, it is indicated. Page 5.
Okay.
After the detection of evidence, my lord, after that, the IO has made categorical mention, my lord. 2 and 3, my lord.
Wherein the deceased Animul Islam was said to have been a victim of a mob lynching. The mob consisting about 500 persons or so. Amongst those who have been arrested, some of them have been enlarged on bail, and some of them are still in custody according to the degree of their involvement. It is the submission of the learned. It is also the submission of the learned additional PP that since the charge sheet has been filed and the petitioners herein have been named as some of the accused persons, therefore it would be prudent for the said petitioners to have moved an application for grant of regular bail before the trial court. However, there is no strong objection by the additional PP as far as the prayer made in this petition is concerned. Mr. S.A. Sheikh, learned counsel for the petitioner, in his submission has reiterated that the petitioners are innocent and have been falsely implicated in the case. In fact, they were not even present at the time when the incident had taken place. However, since they were apprehensive of imminent arrest, therefore they have approached this court. They have approached the trial court with firstly with a prayer for grant of anticipatory bail, and on the same being rejected, are now before this court with similar prayer. It is the further submission of the learned counsel that since some of the accused persons have been enlarged on bail. Therefore, on ground of parity, they may also be given the same privilege of being enlarged on bail in the event of their arrest. However, it is reiterated that the petitioners, if enlarged on bail, will cooperate with the investigation, will cooperate with the process of trial, the investigation. This court, on an earlier occasion, had dealt with the case in question, wherein some of the persons said to be involved in the said mob lynching have sought for grant of anticipatory bail, and on consideration of the facts and circumstances of the case vis-a-vis the involvement of the said petitioners / accused persons, this court by order dated 29/8/2025 in AB number 18 of 2025 had granted protection to such petitioners. It appears that the facts and circumstances have not have remained constant, and the only difference is that in the meantime the charge sheet has been filed by the IO. Though the nature of the incident is serious, and the fact that a person has lost his life due to the action of an irate mob, nevertheless, it is also equally important to maintain the well settled and cardinal principle of bail jurisprudence that an accused person under trial is said to be innocent until proven guilty. Next, be that as it may, the prayer of the petitioners in this petition is hereby allowed. The interim bail granted is also made absolute. Next, in the event of their arrest, they are to be they are to be released on bail on the following condition. So those conditions will be, bail will be set at
Yes,
50,000.
yes.
50,000.
Master.
Item number 3.
This is a land matter, my lord, which involves the Aking land, my lord. Now, my lord, in Garo Hills, my lord, in the tribal areas,
Yes,
Lord.
that has not been admitted.
this is for motion, my lord. For motion. So, my lord, this matter came up before the other bench yesterday, my lord. However, the coordinate bench could not take up the matter, and it's listed today before your lordship. So, motion. My lord, short issue involved in this matter is in relation to Aking land, my lord. Aking land. Aking lands are, my lord, clan lands, and the clans, the clan land, my lord, is in the custody of the Nokma. The Nokma. In this case, the petitioner number 1 is the Nokma, my lord. Petitioner number 2 is the daughter, who's the next in line Nokma, my lord. Now, the issue involved is, my lord, regarding Danagre Aking, my lord, which is almost the entire Tura town, my lord. Now, these are tribal lands, belongs to the clan in the custody of the.
Submit, my lord. I want to place this order of the division bench, where probably my lord was also a party to it. No, my lord was not there. This matter has been decided, my lord. Partially, it has been decided, And they said, my lord, the petitioner was too late, my lord. It was the husband who was approached along with the wife. Now, probably, my lord, the wife.
Same petitioner.
Same petitioner, my lord. My lord, may kindly see. My lord, may kindly peruse.
Give him a
I'll
copy.
one copy just now. I got a.
Just let him go through.
My lord. This is 11. WA11 up to 9. This the husband and wife came at first round of litigation, my lord. Now, my lord, it is the probably the wife and another person has come, my lord.
Well, we can examine this judgment, no doubt, my lord. But as on today, I am aggrieved by the actions of the government. What had happened is, my lord, these Aking land, subject to what this judgment says, my lord. I'm just submitting my matter. Now, recently, my lord, we had submitted an RTI, my lord, before the district council, and the answer to the reply to the RTI is at page 20 regarding these Aking land given by the district council. This is annexure 4, page 20.
Yes.
So this is the reply issued by the district council, and answer number 1, my lord, it reads, as per the record in the map and Warang, Tura falls under the Aking, Danagre, Aking. So the petitioner is the Nokma of Danagre, Aking. And number 2, my lord, Tura Reserve Forest, bracket D Reserve, falls under Aking, Danagre, Aking, as per map. Copy of the map. Now, with respect to, my lord, if your lordship sees with respect to Patta at serial number 7, because GHDC is the authority to issue Pattas. GHDC says GHDC cannot issue Patta without the Nokma's written document except in Moza so-and-so. So, my lord, even as per the district council themselves, who issues the Patta, they say that it is the Nokma who's the customary authority to give the NOC. Now, recently what happened, my lord, at page 22. Now, the state government is labeling these tribal lands, my lord, which is the clan land, Aking, as government land. Can you have page 22? This is a letter issued on 8th of January 2025, my lord, to the district council, my lord, by the Deputy Commissioner, Revenue, West Garo Hills. So they seek for documents. So the subject says furnishing of class of land. With reference to the subjects cited above, I am to request you to kindly furnish the class of lands in respect to the following localities under government lands. Now they label these lands as government lands. This is where my grievance is. To the office of the undersigned on or before so and so. Now, in reply to this, now the localities are page 23, my lord. These are almost all the localities of Tura town, page 23, for which they are seeking for information. Page 24, my lord. District Council writes to the Deputy Commissioner, my lord, Revenue. It reads, my lord, with reference to the subject cited above, I am to request you to kindly furnish the Patta, ownership documents, land acquisition, my lord, land acquisition, documents, etc., so as to enable this office to provide the classification of land or further necessary action. So even the District Council itself has sought for clarification from the government. Please show us the documents that these are government lands. Now, without providing so, recently in November 2025, at page 25, my lord.
Yes.
Page 25, this is dated 18th of November, type copy your lordships will find at page 26. This is where I am aggrieved. So now, as late as November 2025, 18 November 2025, my lord, Deputy Commissioner Revenue issues a letter to all the locality heads. And in fact, these are not locality heads, these are development committee. These committees are formed to implement the schemes, my lord. They are not the Gaumbura, they are not the headman. It's just a committee to implement the schemes. Now, the subject, it reads, my lord, meeting scheduled on settlement of government land in Tura urban areas. So they're seeking to settle lands as on today, my lord, when there's no clarity whether these lands are government lands, whether they have been acquired or not, my lord. So this is what I'm aggrieved with, my lord, as on today. Let them reply, let them show, let them establish that yes, these lands have been acquired, these are government lands, then I will have no case, my lord. But as on today, notice may be issued to them, let them come and, my lord, establish, bring whatever documents on record. In the meantime, this process of settlement should be stayed. That is my prayer as on today. No further settlement till this matter is decided. My lord. You give me a copy. Huh?
We have yet to see this court. We have not furnished any further information as to whether after the 18th November, what was the, or rather, what is the,
No, my lord, we don't have information, my lord.
whether the, you said the survey,
Settlement, my lord.
whether settlement has been carried out.
Yes, my lord.
To what extent, what are the areas, covered?
These are 9 localities here, my lord, under this letter. So all I'm praying is no further settlement till this matter is decided, my lord.
Yes, who's appeal?
Your Lordship, here, as per the letter dated 18 November 2025, Your Lordship, meetings were supposed to be held on the 19th to the 25th, Your Lordship, for settlement of the land. This has already concluded, Your Lordship. And interested persons have also come forward, and they've been issued pattas also, Your Lordship. And moreover, in this particular acting, Your Lordship, some of the land has already.
Who has the authority to issue patta?
Your Lordship,
if it is a government land, my lord, then it is the revenue department. If it is a government land, and if it is a Aking land, then it is the district council who issue the patta on the basis of an NOC issued by the Aking Nokma, my lord. But the question is this, my lord, whether this area falls under the Aking land or an urban land. That is the question, my lord.
That is exactly his contention.
Yes, my lord. But the first round of litigation, which they have approached, my lord, for the municipal market, my lord, of Tura, the same issues was argued, my lord. This is the judgment. So there, my lord, it was said, my lord, that they are too late to come. Moreover, my lord, there is all serious disputation of facts. Which area falls under which urban or rural, or it is Aking Nokma. So in the writ proceeding, my lord, whether this court can decide this. However, my lord, I am entering appearance for the respondent, my lord. Some of the respondent, I will file my affidavit.
Your Lordship, as per my instructions, land was acquired in the year 1975 and 1978, Your Lordship. So this land that they are referring to, Your Lordship, is government land. So, Your Lordship, I have objection to this, Your Lordship. Let us file our affidavit in the matter.
Yes, I don't think.
I'm only praying that no further settlement process.
In the long run, if it is found that the land was actually acquired by the government, then what will happen is that we are interfering with the process.
Yes.
Correct, my lord. But here,
secondly, if, okay, let's put it this way, finally you succeed, then the recovery process will be there.
Yes,
my lord.
So I don't think it will be, prejudicial to any party.
Then my lords may say subject to outcome.
Let the counter affidavit be filed, and we'll see.
My lord.
All the parties are responding.
Yes, I am for respondent number 5 and 6.
How many respondents are there, Mr. Nongri?
My lord, I don't think my learned friend will be able to appear for 5 and 6 together, because it will be a conflict of interest.
My lord, that
GHDC. No, I'm pointing out.
We'll examine, my lord. If there will be conflict of interest, I will inform to the respondent, my lord, who has directed me to appear, my lord.
Oh, municipal board.
My lord.
Yes.
So either notice has to go, my lord, to one
they
of them.
They have directed me to appear. Notice was served upon me. Okay. I have communicated to them. They said you appear. If there is a conflict of interest, my lord, I will appear for one person only.
Leslie.
Let them give me the instruction,
my lord. My lord. So all parties are represented.
Heard Mr. Iliban Nongri, learned counsel for the petitioner, who has submitted that essentially petitioners are aggrieved by a communication number, I took a page 26 one, so and so dated so and so, issued by the Additional Deputy Commissioner,
Revenue.
West Garo Hills. The contention being that the process of settlement of alleged government land is contrary to the factual position as far as ownership of the land in question is concerned, since the said land is a king land, being, what's the name of the
Danagri, my lord.
Danagri. Danagri, 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 a king. And by the said communication, the process of settlement has started and is ongoing, thereby depriving the petitioners of their right to be depriving the petitioners the right to be heard as far as assertion of their right and title over the said land is concerned. It is prayed that this petition may be allowed, may be admitted, and notice be issued upon the respondents hearing. And also in the meantime, the ongoing process of settlement by the said communication dated 11th November 2025, 18 November 2025, Supra be put on hold. Ms. Jadi Nokali Leonard G has accepted notice on behalf of the respondents number 1, 2, 4 and 7, and has also resisted the prayer for interim stay as far as the settlement process is concerned, on the ground that the land in question has already been acquired by the government since the year 1975. As such, the issue of title and ownership has already been decided then. Mr. SD, Learned Counsel, has also accepted notice on behalf of the respondent
5 and 6.
5 and 6, and has submitted that he may be allowed to file a counter affidavit on behalf of such respondent. This court, on consideration of the submission made, is inclined to admit this petition, and since all the respondents have been all the respondents are represented through their respective counsels, no formal notice is required to be issued upon such respondents. Let the counter affidavit be filed in due course within the next date fix. As far as the interim prayer is concerned,
May only issue notice in this case.
Without going to the without considering the merits of the matter, this court is not inclined to allow such prayer at this point of time. You've received copies of the this is matter after petition.
Deeply.
Item number 5.
May please, my lord. My lord, I filed this instance appeal petition being aggrieved with this impugned judgment passed by the London Special Judge NDPS on 13 November 2025 in Criminal NDPS 9 of 2015. My lord, the appellant was convicted for offence under Section 21B NDPS Act and has been sentenced to 5 years rigorous imprisonment and a fine of rupees 1 lakh, and in default 1 year rigorous imprisonment. My lord,
Notice issued.
My lord, it is in the admission stage, my lord.
You're accepting notice?
Yes, my lord. I'll accept notice. On behalf of the state.
Or Mr. Sharon Ladman, counsel for the petitioner, for the appellant, was submitted that the appellant, being aggrieved by the judgment, by the impugned judgment and sentence dated 13/11/2025, passed by the Learned Special Judge NDPS Shillong in criminal NDPS case number 9 of 2015, wherein the appellant was sentenced to undergo imprisonment for a period of 5 years with fine.
5 years here, my lord.
With fine.
Five
With
years.
fine of
With
rupees
5, there's a 1 lakh.
With fine of 1 lakh for alleged offence under section
21B of the NDPS Act.
21B of the NDPS Act, has now approached this court with this. It's an appeal. A prayer is made for the appeal to be admitted. Mr. S. Senator Additional PP has accepted notice on behalf of the state respondent and has no objection to the admission of this appeal. Appeal accordingly admitted. The trial court records are hereby called for. As and when the records are received by the registry, the appellant is directed to prepare the paper book. This is matter of the petition.
Lordship,
This-
item number 3, Lordship. We are just praying for your Lordship's indulgence. Item number 3, appeal matter, Lordship.
Yes.
It may be listed in the vacation in the month of January, Lordship.
My lord, I filed an application or this application for the suspensions of the sentence.
That will be taken up. Let the records be produced. To add into on the prayer made for suspension of sentence, the matter will be taken up as and when the trial court's record are produced.
Much obliged, my lord.
Item number 6.
May it please, my lords. The bill under the NDPS Act, respondents were to produce the CD. It was moved on the last date, lordship.
Yes.
Still waiting for the case diary, your lordship.
The matter is already charge sheeted.
How long was he in?
Lordship, he has been arrested on 1st of August 2025. The case is that a person was caught on body search by the police, and certain contraband was found from his possession, Then thereafter, on interrogation, it appears that he took the name of this present accused person. So he was also arraigned on the basis of his bank statements. Bank statements in the sense that, Lordship, that on a particular day, 2 or 3 days before the incident, he had received an amount of around 40,000. And on the next very day, he had transferred an amount of 30,000 odd amount to some other person. Now, we have explained, my lord, from the bank account also that 40,000 was his government salary. He is a government employee. And the 35,000, it is not the first time that he has made those transactions. He is actually giving this money for the treatment of his cousin's wife. So it is not the first time only on that transaction has been made. There are a bunch of transactions to that cousin brother and his wife. But in any event, my lord, he has been arrested and implicated. There is nothing in the investigation which has come out except for the disclosure statement made by the co-accused. Now that, my lord, at this stage, I am not getting into it because at the end of the day, that is not admissible in the trial as held by the Tufan Singh judgment. But in any event, my lord, the case is that what has been seized is suspected to be a contraband. There is no FSL report in the charge sheet. Be that as it may, my lord, the case is a 21B offence. It's an intermediate offence. Now I have been charged under 29 abatement. And they say, my lord, the learned trial court says that since I have been charged for financing and abatement, rigors of 37 will apply to me, but not to the main accused, who, despite that the case is under 21B. My humble submission is, Lordship, that he is a first time.
Section 27 is so involved.
Yes, 27A and 29. But my humble submission is, Lordship, that I am a government employee. My financial banking transactions have not been proved to have any nexus with the drug trade or otherwise. I am coming clean and saying that this is why I have transferred the money to so and so person. That can be easily verified. These are UPI transactions, Lordship, not cash. And charge sheet is already filed since the month of September. Charge has not been framed till date. I am lying in jail, my lord. I have been suspended from my service also on account of my arrest. I have no criminal antecedents, Lordship. And my humble submission is that, interestingly, this was a case of a source information about someone traveling with drugs. That person was caught. No notice under section 50 was given to him before the body search. Now when that issue was raised, what they have done is they say it's a chance recovery. But my humble submission is, when source information was there is no question of a chance recovery, my lord. So in any event, my humble submission is, Lordship, to come to a final finding that what was seized is a contraband, there is no FSL report. The possibility of tampering the witnesses, who are all police personnel, does not arise, my lord. I don't have any criminal antecedents. I've been in jail for about 3 to 4 months now, my lord, without the trial having progressed at all. And they have mentioned, my lord, in the charge sheet that there is one other person who is against whom the investigation is pending. Now that, my lord, is not a ground to keep me in jail. Against my formalities, everything is complete. Charge sheet is filed completely against me for an offence of financing and abatement. Abatement, what has been seized at the end of the day, is a 21B quantity, my lord. So my humble submission is on very strict terms and conditions, considering his background and his lack of any antecedents, and the fact that it was not that he has been found along with the co-accused or anywhere near the vicinity of the PO. He was picked up from his home on the basis of the bank transaction. But my humble submission is that bail may be considered on very strict terms and conditions, and I'll face the trial.
But you have a copy of the charge sheet?
Lordship, I have enclosed in the bail petition. Yes.
Then, yes, Mr. Kala. Question of
charge sheet I have enclosed.
Yes, yes, complete set.
Lordship, yes, 22. Along with the FSL, I mean the medical and everything. So it starts from 22, my lord.
So, to the court, your lordship. No objection, your lordship.
And the lordship may kindly see.
Have you approached the trial court?
Lordship, yes, we have approached. In fact, once at the initial stage of arrest, that was rejected on the ground that it's a very too early in the day, my lord. Then we have approached again after the filing of the charge sheet, but nevertheless, my lord, it was rejected on the ground that I have not served 1/3 of the punishment. That is, my lord, punitive in nature. And they say, my lord, since the pending other accused is still pending investigation and he has not been found.
Where's that order?
Lordship, please. Lordship may kindly have the order at page 108, Lordship. Oh, this is an order of 1st December, Lordship. And
So practically you have advanced the same argument before the trial court.
Lordship, yes, more or less, yes. And what I'm also submitting, my lord, that considering that the main offence, alleged offences are of an intermediate quantity, just because I have been charged under 27A would not mean, my lord, that mechanically the rigors of 37 would apply. NDPS Act.
NPS.
And there is a finding in the bail order, my lord, at the last page 121, that reasonable grounds that the accused was in illegal conscious possession of the contraband. I was never in possession, my lord. There is no seizure list also, insofar as I am concerned.
How many accused persons have been arrested?
Also two. One is this Rudy Sutrana, who is the petitioner's husband here, and one Kimin Langdakhar, again from whom the...
So who is this Kmen Langkar? How is he connected to you?
He is not, my lord, he is not. That is what I am saying. What has happened, I'll just take your lordship through the chart sheet. If lordship may kindly see the Panchnama, my lord, what had actually happened. If lordship will see page 46, lordship. This is the type copy of the Panchnama.
Yes.
At around 1:50, self so-and-so was deputed at Rajatara checkpost after receiving telephonic information from so-and-so to the effect that one person was found suspicious of carrying illegal contraband on his body. Now at 2 p.m. arrived at the spot PO. At around 2:54, search was conducted from the search person who was identified as so-and-so, and in the presence of independent witnesses who was travelling on one sumo tourist white color bearing number so-and-so, driven by Shri Michael Sana, son of late so-and-so, coming from Silchar side. During his body search of the suspected person, detected one black plastic polythene hidden inside his underwear. On opening the same, one soap case was found containing yellow-orange color powder, suspected to be heroin, my lord. So this was the background of the case, and thereafter, lordship may kindly see in the chart sheet. Kindly have page 28, lordship.
Page 28.
Lordship, yes.
Yes.
Lordship, it reads, my lord, arrested, accused, forwarded and produced before the Honorable Court. Twenty-eight, lordship. This is part of the chart sheet. Lordship will see the first part, if I may just rely. Interrogate the accused person. It's given on the left side, highlighted.
Okay.
It says, my lord, the accused person, Rimli Kimanlang Dakhar, was interrogated into by the seizing officer and his statement recorded under 180 BNSS. And it was on the basis of this statement, my lord, that I have been implicated. And how I have been implicated, lordship will find that at page 29, lordship.
Yes.
Page 29, my lord. The heading is Drawal of Samples for Sending to FSL in the Honorable Court of CJM, Clariat. In the middle of the page, my lord. Drawing of samples. Lordships have it.
Interrogate the accused person during course of investigation.
As prayed for, page 29.
Page 29.
Yes. The heading is Drawal of Samples for Sending to FSL. In the middle, lordship.
Not here.
The heading of the paragraph.
Not here. Just a moment.
Or lordship may see 29, the type copy. There's a type copy also.
This is 29A.
Lordship, yes, 29A. I'm sorry. 29A. I'm sorry.
Yes.
Lordship, it says the second paragraph below this heading of drawal of samples. First paragraph, I'll just skip. It talks about sending the sample to Assam.
Yes.
Second, during investigation, as per the statement of one of the arrested accused persons, Shri Ridhu Sutana, he admitted that an amount of 45,000 has been transferred to one middleman for procuring drugs for him from Kalain. On examination of his SBI statement transaction dated so and so, it was found that such transaction actually took place and found to be true as per available records, where he transferred such amount vide so and so, so and so, so and so at so and so. This is an UPI transaction, my lord. Now that UPI transaction also I have enclosed. This was given to one Miss Patience Pale. She is the wife of my cousin, my lord.
Okay. There is no nexus between this Menlang Dhar and that Pali.
Lordship, no, nothing in the charge sheet. And in fact, Lordship will see page 30. This is the last part of the charge sheet, my lord. Page 30. The case has been discussed and deliberated with senior officers and supervising officer of the case. They are also of the view in unison with my opinion to file charge sheet against the arrested accused person involved in the case. Therefore, taking into consideration and after scrutinizing and analyzing the strong and unequivocal evidence on record which were collected and seized during the course of investigation, it is prima facie proved beyond reasonable doubt that a case under 21B, 27A and 29 NDPS Act is found well established against the arrested accused persons. It is therefore prayed that the Honorable Court that Shri Kemenlang Dakhar, so and so, may be prosecuted under 21B, 27 capital A and 29 NDPS, whereas Reddy Sutana, so and so, may be prosecuted under 27A and 29 capital S, whom I send them up to stand trial in the court of law under the aforesaid section of law. A supplementary charge sheet will be submitted soon after receiving of FSL report and arrest of co-accused person who is involved in the incident case. Now, who is that co-accused also we don't know.
Heard Mr. Step-level counsel for the petitioner, who has submitted that the case of the petitioner herein that when did the incident took place?
Lordship, that is on 1st August, Lordship. I'll take your Lordship to the FI at page 32. I'm sorry, to 31st July. So page 32.
Lordship?
Yes.
To receive the CD, my lord.
No, your
matter is charge sheeted, Lordship.
Your colleague has already made a submission. CD is not required because the charge sheet, the copy of the charge sheet is here.
Lordship, but we're having objections, my lord. I'm sorry, I was not here. I was in the other court, Lordship.
Your colleague has already made the submission. That submission has been noted. He said there's no objection from his side. So
My
now
lord,
you're saying
I'm sorry, my lord. I was on legs on the other court, Lordship.
how can the two of you stand on the same side and be and make
That is very
conflicting
prejudicial to
submission?
me. FIR at page 32, Lordship.
Tunggu. On the basis of an FIR lodged before the Kiang Police Patrol Post, East Jante Hills, on 31/7/2025. wherein report was made that the police in the anti-infiltration checkpost Ratachera, while conducting vehicle checking, had intercepted one vehicle under bracket Tata Sumo tourist white color number ML04B 4487 and upon searching, the person of one Sri Kamenlang Khar had seized contraband substance from him, suspected to be heroin. Accordingly, following due procedure and formalities, a case under the NDPS Act was registered and the said suspect was arrested in connection thereof. In course of investigation, another person was arrested, another person suspected to be involved in the transaction of the contraband substance, namely what's his name?
Rudy Sutana,
Rudy
page 24.
Sutra was also arrested. The primary allegation against him is that he is instrumental in financing the said operation, wherein an amount of rupees 45,000 was detected to have been transferred from his account, presumably for procurement of the said contraband substance. In course of investigation, the investigating officer has noted that there are evidence against the said main accused person and also against the co-accused person, namely Sri Rudy Sutra, and accordingly, on a well-founded prima facie case, the IO had referred the matter to the competent court of jurisdiction for the accused person, including Sri Rudy Sutra, to stand trial for having committed an offence under section 21B oblique 27A.
Lordship,
Oblique
as far as Rudi Sutuna, they has been only charged under 27 capital A and 29.
27A oblique 29 NDPS Act of the NDPS Act 1985. It is the submission of the further submission
No
of the
charges framed.
charges have been framed.
Not yet framed, Lordship. Maybe they will.
It is the charges however, charges have not yet been framed till date. It is the further submission of the learned counsel for the petitioner that the petitioner, that the accused, who is the petitioner?
She's the wife, Lordship. She's the wife.
The accused husband of the petitioner, that is Sri Rudi Sutra, is not at all involved in the whole operation, and in fact, as regard the said transfer of 45,000 from his account, the same was sent to one Srimati patient
Pali,
who is his sister-in-law.
Lordship, yes.
Who is his sister-in-law? For the cost of medical treatment of her husband.
I mean, of herself.
For the cost
For
of
medical
treatment to her. This transaction has been construed as the reason has been construed as one of the involvement of the said accused person in question in financing the operation by the said main accused person, Sri Kamenlang Khan.
Lordship, yes.
When in fact the accused person in question is not at all known. He is not known to. Not at all known to said Kamenlang Khan, and has known, and there is no nexus whatsoever as far as their relationship is concerned. On this premise, the General Council has submitted that there being no concrete evidence as far as the involvement of the accused person in question is concerned, and the fact that he is also a government servant, and the said amount transferred from his account being part of his salary packet. Therefore, his arrest is uncalled for, and also considering the fact that the charge sheet has already been filed, therefore it is prayed that under such circumstances he may be allowed to be enlarged on bail. It is also the further submission of the London Council that admittedly the seized contraband substance is that of an intermediate quantity. However, because of the alleged involvement of the accused person in question, attracting the provision of section 27A/29 of the NDPS Act. Therefore, the operation of Section 37 of the NDPS Act has come into force, which in fact ought not to have been so. It is prayed that the accused person, having been in custody for how many months?
4 months, Lordship, from 1st August.
4 months.
Over 4 months.
4 months or so, he may be enlarged on bail with any condition deemed fit and proper to be imposed by this court. Next. Also heard Mr. Yampala Leonard GA appearing for the state respondent, who has submitted that the case diary as called for could not be produced today. And has sought for time for the same to be produced. However, in the light of the submission made by the learned counsel for the petitioner, that the case has been charge sheeted and copy of the charge sheet in its entirety has been annexed with this instant application. Therefore, the production of the case diary is not necessary, and this court can come to a decision in the matter on the basis of the papers annexed herein. Accordingly, Leonard J has submitted that the state has no objection to the prayer made and has left it to the discretion of the court to pass necessary orders. This court has considered the submission made without going into the detailed facts and circumstances of the case. However, on the basis of what has been submitted and on perusal of the petition in hand, where is the 161 of that Kumenlang Khan?
Lordship, there is a disclosure statement. I'll just take a look at that. Page 48, Lordship. Page 48 is the handwritten, page 50 is type copy.
This is the disclosure memo.
The statement is mentioned below that, Lordship.
Okay.
The type copy is at 50. My name is so and so. I am addicted to.
Would notice that from the disclosure memo, I under small quote it over, is found the statement of the said accused Kwen Lang Dakhar, who had stated that, I quote more, I used to take purchase drugs from Rudy Sutanga consumption and also for the purpose of selling. Stop. I know Shri Rudy Sutanga and Shri Lenny Rambai since I started to take drugs. Stop. Next. On 30/07/2025 at 7 a.m. Shri Rudy Sutanga dropped me Tershi to Joy to proceed to Kalyan, Assam for acquiring drugs, as Shri Rudy Sutanga has already transferred 40,000 I got to no 40,000 to Shri Jotu and transferred the money to dealer at Kalyan. The remaining amount of my own cash I don't to wait more. Is found a disclosure. Okay. Though the learned counsel for the petitioner, has contended that there is no relationship or nexus between the accused person in question, under bracket Rudy Sutanga, and Shri Kwen Lang Dakhar. The said disclosure statement, however, says otherwise. Again, next one. As far as the transaction of the money is concerned, it may be true that Sri Rudy Sutanga had indeed transferred the said sum of rupees 45,000 to his sister-in-law for her treatment. But the fact that the accused Kwen Lang Dakhar had clearly stated that a sum of rupees 40,000 was transferred to one Sri Lenny Rambai and 35,000 one for the purpose of procurement of the contraband substance, would only prove that this could have been a different financial transaction altogether. Next, it is true that the statement of a co-accused made under Section 67 of the NDPS Act is not admissible in evidence. However, for the purpose of bail, this court is not deterred from relying on such statement for the purpose of consideration of such bail, consideration of prayer for bail. Since evidence has not yet been, since charges have not yet been framed and evidence not yet recorded, at this point of time, this court is of the considered view that prima facie a case has indeed been made out against the said accused person in question. Accordingly, this petition is found to be devoid of merit. The same is hereby dismissed. You come back after evidence is recorded.
Published.
Item number 7.
Yes.
My Lordship, I have already taken the steps, but we could not file the affidavit of service and notice because the petitioner is not well, Lordship.
After vacation, Ms. Legal Counsel for the petitioner for the appellant has submitted that the affidavit of service could not be filed since the petitioner is not keeping well. It is prayed that this matter may be posted after vacation. Pray aloud, list the same accordingly.
Item number 8.
May please, Lordship.
Yes.
Lordship, I'm praying for some more time to prepare my paper book.
Yet again, legal counsel for the petitioner has sought for some time to file the paper book. Pray aloud, this is matter of the vacation.
Obliged, Lordship. Lordship, item 8, 9 and 10 are connected.
Same order?
Yes.
8, 9, 10, same.
Obliged, Lordship.
Item number 11.
But I've been informed by the DC that the matter is under active consideration, but considering that the holidays are coming, we'll need at least 3 weeks' time to pass necessary orders. Consider.
So you wait.
Yes.
Because once the matter is considered, then there's no more cause of action.
Yes.
Consider has two-way meaning also, Your Lordship.
No, whatever the case may be, it might go this way, that way, whatever the case, you will still have a fresh cause of action. Mr. T.T. Devro, Learned Senior Counsel and Special Counsel for the respondent KCDC, has submitted that on its being instructed, it is submitted that has submitted that name and being instructed, it is learned that the relevant authorities in the KCDC is seriously considering the case of the petitioner hearing. However, because of the ensuing holidays, the same could not be done so immediately. It is prayed that some time may be allowed for this matter to be for a specific report to be filed in this regard. Accordingly, let the status report be filed on the next date fix. This is matter on 28 January.
Your Lordship, I'll take steps on respondent number 5. There's a private respondent.
Who's, I thought all the respondents are.
Those are the complainants.
In the meantime, petitioner has prayed that he may be allowed to take steps on respondent for issuance of notice on respondent number 5.
Respondent number 5 by registered post as well as by dusty service.
That is so. By registered post, we will buy dusty service. We are allowed to carry 28 then?
28.
Can it be in the first week of February?
28 Jan is almost more than 3 weeks, Lord.
What do you suggest? Should I come on 15
January?
January?
29 December.
It's not so urgent. See, the sky will not fall.
Your Lordship.
So, this is matter on in the first week of February.
Macam.
Alright.
Court yang ketuka pemenang to number 1.
Second call from supplementary list, item number 1.
May it please your Lordship, this bail application is preferred before this honorable court by the accused applicant.
Honorable Supreme Court inadvertently missed to mention it, Lordship, regarding the appointment of checkers. It may be deferred till vacations, Lordship.
Mr. Lee has submitted that. The related matter is still pending for the Honorable Supreme Court. As such, this matter may be adjourned for the time being. As prayed for, this is matter after 6 weeks.
Obliged.
From supplementary 1, item number 1.
Yes, who's petitioner?
May it please your Lordship. Your Lordship, the accused person was arrested on the 12/8/2025 based on an FIR dated 2nd March 2023 under section 21C, 25, 29 of the NDPS Act, your Lordship.
Commercial quantity?
Commercial quantity, your Lordship. And he was arrested on 12/8/2025 based on the FIR dated 2nd March 2023. Your Lordship, the police here has seized 1,393 bottles of fentanyl and 2,864 strips of tapentadol. Your Lordship, the accused person here is a businessman. He is supplying grocery items, and he has supply a consignment of drinking water, then nimbu pani and mango juice to one Srimati Silarin D. Shira through Shri Om Prakash Tanwar, the owner of the Bolero pickup. Then, your Lordship, the accused person mentioned in the FIR, that is Dilbar Ali, Monowar Ali and Subhash Barman, were already arrested on 2nd, 3rd, 2023, and they are at present they are on bail, your Lordship. So, your Lordship, here in this bail application also I'm seeking on principle of parity, your Lordship, as the other accused are already on bail. And your Lordship, I'm seeking bail also on medical grounds. Your Lordship, the accused person here, your Lordship, is a patient of kidney stones, then fatty liver and fatty pancreas, and even his wife also, she's a patient. She has some eye tumor, and she was due to be operated, your Lordship, in the month of August 2025. But as the accused person was already arrested during that relevant period of time, your Lordship, hence even her operation also is delayed, your Lordship. And your Lordship, here the accused person was arrested merely on the basis
under the old CRPC and now 106 and 107 under the present BNSS. But those were not exercised altogether. They kindly have the impugned order that is at page, my lord, 86. Sweeping powers, my lord, just I can only reminiscent of that Henry the Eighth, my lord, in England. Henry the Eighth clauses, my lord. This is something like that. Have page 86.
Henry VIII has used to pass these kind of orders.
He usurped the entire powers and took away all the church's powers also to himself and became the custodian of the entire church. And he executed every minister of his, whoever does not fall.
Where is the similarity here?
Similarities kindly see, my lord. I see the similarity because under the constitutional scheme, my lord, the deputy commissioner does not enjoy this kind of power of freezing of the bank accounts. Kindly have page 86, my lord. This is dated 15th of February 2025. Issued by Government of Meghalaya, Office of the Deputy Commissioner, Reboy District, Nongpo, and issued to the branch manager, my lord. All the banks are here. Subject: for compliance of the judgment order dated 13th of February 2025 passed by the Honorable Supreme Court of India in respect of civil appeal number so and so, CMJ Foundation and others versus State of Meghalaya and others regarding debit freezing of bank account. Sir, with reference to the subject cited above, I am to request you to freeze the debit transaction of all bank account related to CMJ University and CMJ Foundation, including the bank accounts mentioned below. Various bank accounts are here, my lord, including the foundation and the university, more than 300. And kindly have page 92, my lord. This is in compliance to the judgment order dated 13th of February passed by the Honorable Supreme Court of India in respect to the so-and-so Foundation and others versus State of Meghalaya. This is for your information and necessary action. Executive order. Kindly have the Supreme Court judgment. I have annexed that judgment also. And the issues, it starts from, my lord, the judgment is a lengthy judgment. It starts from, my lord, page number 34.
Page 34.
Page 34, my lord. It starts from page 34. But the issues which fell for determination, page 34, my lord, the judgment starts, on which the respondent has relied upon, and the issues for determination which fell for consideration were civil in nature, and they are mentioned at page 59, my lord.
Yes.
The following key issues are posed for consideration of this court in the instant appeal. Whether the appointment of the Chancellor of CMJ University was made with due adherence to the procedure as mandated by law. Whether the dissolution order dated 31st March 2014 was passed with due adherence to the procedure provided under Section 48 of the CMJ University Act and in compliance of the direction issued by this court by the order dated so and so in CMJ Foundation versus State of Meghalaya. Whether the division bench of the High Court of Meghalaya was justified in remanding the matter to the learned single judge for reconsideration on merit while allowing the writ appeal number 14 of 2017. And after answering all these questions, my lord, in affirmative, kindly have page 81, my lord. I would not take my lords to all but the conclusion is mentioned at page 80. And all these issues will be also addressed in a very crisp form.
Yes.
Page 81, Roman 4. The decision of the state government dated in dissolving the university is affirmed. It would be open for the state government to take appropriate measures pursuant to the affirmation of the decision to dissolve the CMG University. In view of the above and for the reasons stated above, civil appeal filed by appellant is found to be without merit and deserves to be and is hereby dismissed. Conversely, so and so filed by the state is allowed and direction given by the division bench to remand the matter of the single bench is set aside. And a new judgment is modified to this we filed a review. And the review, my lord, that is also very important, because if my lords may kindly have the review judgment.
Yes.
This is dated 9th of December. I'll just give you a copy. All the issues arising out of the interlocutory application fall within the domain of the UGC, and it is for the Commission to take an appropriate decision on the matter and implement it. We also make it clear that the University Grants Commission has the authority and jurisdiction to take such action as may be necessary with regard to the validity of all the degrees issued by the university. Now I ask myself, where does this Deputy Commissioner, my lord, gets the power? Because Supreme Court does not reiterate in anywhere, my lord, it was exercising civil jurisdiction. It was not even asking or gave a direction to freeze the bank accounts for everyone under the sun. I can expect, my lord, the university, my lord, could have been, but for the huge foundation, for everyone named, my lord, even the pan wala, the cement factory who gave the cement to the university, my lord, his accounts are also being frozen. And Shruti Jha, one of the petitioner is Shruti Jha. She has got no concern with either the foundation or the university, including the lawyers, my lord, the chartered accountants, everyone, my lord, whoever dealt with the foundation or the UG or the university, his accounts come to be frozen. And under 106, my lords, may kindly have 106 also under the BNSS, because that is the only ultimate power for any authority to defreeze the bank accounts. Kindly have that also, my lord, the BNSS section 106. This is, my lord, slightly modified version of 102 now. Power of police officer to seize certain property. Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offence. Such police officer, if subordinate to the officer in charge of a police station, shall forthwith report the seizure to that officer. Every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction, and where the property seized is such that it cannot be conveniently transported to the court, or where there is difficulty in securing proper accommodation for custody of such property, or where the continued retention of the property in police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person on his executing a bond undertaking to produce the property before the court. As and when,
Mr. Singh,
please, my lord.
This is the power given to a police officer.
Police officer.
But the impugn order was passed not
by the deputy commissioner. So I ask myself, my lord, from where is he getting the power?
Why are you referring to this?
Well, I am referring because ultimately, my lord, the only power known to canons of criminal jurisdiction is under 106 or 107. And I wanted to, my lord, just emphasize that even the police officer, even if he is wanting to, my lord, seize any property, he has to also go to the magistrate, either get a post facto under 106 or pre facto under 107. This, my lord, deputy commissioner, my lord, the respondent herein has neither reported it to the magistrate, nor either post facto or pre facto, my lord. So he is, my lord, acting under what authority? This is the, my lord, right to, my lord, continue having a bank account is a fundamental right. Various Supreme Court judgments are there. Now Supreme Court has also envisaged, my lord, that under 106 also the police can't actually, my lord, issue the notice or debit freezing of bank account without the proper, my lord, orders from the magistrate. And that is the judgment, my lord, in the case of very recently, in the case of State of Kerala versus Headstar Global Private Limited, in criminal SLP number 13433 of 2025, dated 11th of September. Supreme Court has deprecated even the investigating agencies also to to issue freezing order with regard to debit freezing of bank account. Here, my lord, the deputy commissioner, without having any power, but I don't have the, my lord, I have got the, but I'm just saying, since my lords are not to, but this is not under the criminal law, I'm just, my lord, making a reference just like I did for the Henry VIII, my lord. Not that I would to produce all those clauses of Henry VIII. This judgment, my lord, only is with regard to the 106 and 107, got no connection with, but this is with regard to, just like under the National Disaster Management Act, it must have been here also. In 2020, the states passed the legislation under the clause for waiving of the fee. Supreme Court, my lord, ultimately had to set it aside that the state also does not have the power to do that under the subordinate legislation. This is something like that, my lord. Deputy Commissioner can't withdraw power from, my lord, anywhere to use this power to do the debit freezing of bank account. So I asked myself, from where is he getting the power, my lord?
Yes, miss.
And we have made, my lord, various representations, my lord, right up till now, and he has not even responded once.
This is since February 2025. Why have you come now?
But they are all represented 2025 only.
Yes, 2025. Now we are in December.
No, my lord, but we are making a representations, my lord, all throughout.
Okay, okay. When
and he has, my lord, what he has done is, in the meantime, when we issued him a cease and desist notice.
Where are your representation?
They are all, my lord, a part of from page 793 to 101, my lord.
Where is the reply to this?
There is no reply. He is not responding. But we were also engaged in the Supreme Court, my lord. The foundation was engaged in the Supreme Court. Ultimately, this ultimate order has come. And on this basis, my lord, that's the reason we filed this now fresh writ petition. That now he is devoid, my lord, even the administrator also is devoid of most of the thing, my lord. And that writ petition, my lords, are hearing and posted for hearing, my lord, immediately after the vacation. With regard to the validity and the appointment of the administrator also, with regard to my dissolution. 253, writ petition 253 of 2025, my lord. And this order need to be, my lord, immediately stayed or vacated, my lord. Otherwise, this violates the basic canons.
Yes. Yes.
Please, Your Lordship. Speaking of the present day, we see King Charles, not Henry VIII, my lord. So presently, my lord, as per the application of the law, if my lord could kindly go to page 3, Lordship, of the petition. We have the petitioners, my lord, 1, 2, 3, 4, 5, 6, and CNJ Foundation represented by so and so, Lordship. My lord, thereafter, kindly go to page 31, Lordship.
Yes.
Lordship, we have again petitioners 1, 2, 3, 4, 5, and 6, but CMJ Foundation is not represented here, my lord. Thereafter, my lord, to the next page, 32, Lordship. Affidavit is sworn only by the petitioner number 5, Lordship. And nowhere is there any authorization for the petitioner number 5 to represent the other petitioners, Lordship. So this is our first objection, Lordship.
Yes.
It has to be authorized, otherwise all 7 sign the application. Secondly, my lord, my friend has come here on the 17th of December seeking a stay order of the order passed by the district dated 15th of February 2025. Where were they all this time, my lord? And whether these people who are named here in order of 15th February, have they been authorized to represent them as well? Because they brought this letter before this honorable court seeking a stay of the same, my lord. So on these conditions, my lord, but firstly the locus, lordship. He has not been authorized to represent all the petitioners, and this is where the writ petition is defective.
All petitioners are here, my lord. Page 86.
Kindly go to
Right.
the affidavit, my lord.
Have page 86.
Before my son
Chandra
goes
Mohan
there,
Jha.
kindly
Chandra
go to
Mohan
the
Jha is the
affidavit,
first
my lord.
one.
The affidavit will show that he is not authorized to represent the other petitioners.
Yes, Mr. Singh.
But even for one also, supposing I take it from my learner friend, I'll meet that argument also, my lord.
No, whatever the case.
There is a Supreme Court direct judgment on this. The technical defects in the memo or in the affidavit or in the wakalatnama are all curable defects, my lord. They can just 1 second, ma'am, 1 second. They're all curable defects and they can be removed. And there's a constitutional bench judgment also, election petition also, my lord. Wherein the Supreme Court has held that in the election petition also curable defect is the affidavit. Affidavit can be also cured. Here also, my lord, I am only urging right now for one. My learner friend is right. She may be right for even if I am representing only one Chandra Mohan Jha, his name is there at the top of the list, Chandra Mohan Jha. Even for one also, my lord, can it be, my lord? Can it withstand this order? Can it withstand against one also, my lord, who is effectively before my lord? Can this order stand on its legs? Even if I point out through one petitioner or on the one account holder that this order is patently violative of fundamental right.
Fine. You see, if that is the case,
please.
Okay. Let's put it this way. And as far as you are concerned, maybe since your name is there, so the order may be passed in your favor. Only with regard to you in particular, not to all the other.
But this order can't stand.
Whatever the case may be, that will be looked into, no doubt.
Very well, my lord.
See, that will be looked into.
Very well. Wherever my name stands, Chandra Mohan Jha, my lord, let it be stayed quiet till that time. Till the next date of hearing, I'll cure the defect, my lord. If my lord's suggestion is that
Yes,
this...
where is...
My lord,
Yes.
they've not even prayed for a stay of the order, lordship.
You tell me, under what provision has this order been made?
My lord.
Compliance of the judgment and order dated so and so.
My lord, that I'll have to seek instructions.
Where is the specific direction that the accounts has to be freezed?
Lordship, I have to seek instructions, but this is the 15th of February order, my lord. And secondly, there's no application for stay, nor has any mention been made in
Prayer
the
B.
main. No, my lord.
Prayer B, kindly have my prayer B, my lord.
My lord, this is not acceptable, lordship. This is not how the court functions, my lord. Not by way of a verbal submission.
Prayer B is not a verbal submission. Kindly have my prayer B. Issue a writ of mandamus or any other appropriate writ or order directing defreezing of the bank accounts of the petitioners.
Exactly. It's not a stay.
It is not a verbal submission.
Order, my lord, that's being sought for.
Defreeze it. My lords may kindly consider defreezing the account of only Chandra Mohan Jha at this stage.
Final disposal, my lord, not at the interim stage.
I think I have to rise because we have a meeting at 1:30.
Have it afterwards, man. Pass over.
No, I've got the parties. I'll pass the orders.
My lord, kindly record
Grateful.
my objections.
Yes.
My lord. Much obliged,
I'm
lordship.
done. You done with you.
Second call from supplementary list, item number 11.
Grateful much.
Oh, item number 11, Mr. Burung was there, my lord.
Please, Your Lordship. Lordship, I beg to make a mention of item 5 of the supplementary list, Your Lordship. Item 5 of the supplementary list, Your Lordship.
Excuse me. No, daily list, sir.
In the daily list.
Main list, sir.
Main list.
Supplementary. 5 more, the supplementary list. After vacation.
It is in the regular list. Supplementary list.
The supplementary list.
Yes,
yes. In rigid does.
Yes,
Lordship. Yes.
No,
Highly obliged, Your Lordships.
May it please Your Lordship, Lordship, I beg to mention item number 7 from the main list, my lord. That is matter come up after vacation, my lord.
After vacation.
Your Lordships, I'd like to mention item number 3 from the main list. Your Lordship, we're praying for some time, like may taken up from after vacations, Your Lordships.
After vacation.
Much obliged, Your Lordship.
Please, Lordship, I beg to mention item number 1 from the daily list.
After vacation.
Much obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 10 from the supplementary list. Lordship, I pray that this matter comes after vacation.
After vacation. Then, supplementary. Takkan mau here.
Please, Your Lordship, I beg to make a mention of item number 6 from the daily list. Number 6 daily list. 6 daily list.
6 daily list.
Daily list.
Yes. all after vacation.
Much obliged, Your Lordship.
My lord, I beg to mention item number 9 of supplementary list.
After vacation.
My lord, if it is possible, then kindly fix the after vacation on 28th January.
My lord, why? What's the hurry?
After vacation, first week.
What's the hurry?
Hello?
I said, what's the hurry?
28th January.
Why are you in hurry to get it done? It's a 25 matter.
28th. Okay, then 4th of February.
4th February.
Okay.
Please, Lordship, I beg to mention item number 2 from the daily list. After vacation, Lordship. Number
After
4
vacation.
and 5.
Two, 4 and 5 more.
Lordship.
My lord, I beg to mention item number 8 from the supplementary list. My lord, yes, Raj Roy.
Are you mentioning item?
Yes, sir.
Well, yes, yes. Malab, in that case, can it be fixed on after vacation on an early date?
You suggested it.
My lord,
28th, if your lordship fixes.
My lord, senior counsel Mr. Chula is leading this matter. He has no objection. Immediately after the vacation can be taken up.
20.
After, on primary parties, this is matter on 28th.
Please, Lordship, I beg to make mention of item number 6, supplementary, Lordship. Supplementary list.
After vacation. 6 more. Kani M kani ka? Daily list kani. Or supplementary.
Supplementary.
Supplementary. Supplementary. M kamin pi ho kamin. Kamin ada. Kani confused.
Supplementary list, item number 1.